the Director of Scholarly Communication, and I'm so glad you are here joining us with Kenny Cruz. I'm just going to give you a few logistical things. First of all, the day. We do have 2 sessions. Today is, I have to remember even though I wrote it, till 11 o'clock, making copyright work for you, ownership and fair use at the university. This is a very interactive workshop. All of them are just jumping with questions. I'm sure Kenny will reiterate that. And thank you all for those that had submitted questions beforehand. I think that was very helpful. And we'll also use that as we go on with library programming and copyright and so forth. And we're going to come back here at 1 o'clock, same room. And there's also an online version. If you can't make it at 1 o'clock, there is the online version. You can go to our landing page, which is here, and I think I've sent it out, and you can also attend online as well if you can't make it back here. And we're going to do special topics in copyright. And again, another very interactive session, and it's going to be online learning, which I think some of you may have some questions about. I'm not sure. E-reserves updates and authors' rights of publication agreements. So that should be very interesting. It will be recorded. So you know, this is going to be recorded, and I will forward the archive and make that publicly available for your colleagues as well at some point. Logistics, bathroom, that's a logistic. It's right there. Am I good?
You are good. And just one comment on the recording. This room is beautifully set up for that. I don't know if you've noticed these little things up in the ceiling. Anything that's said in the room gets recorded.
Oh, no. Can I take it all back?
But particularly where with regards to questions and so forth. However, know that if you have a conversation going on that doesn't have to do with the copyright, it's also being recorded.
You can't take that out afterwards. Everything is online.
So how much are our royalties for?
Every nice amount of online people too.
14 to 15, yes.
Okay,
Right.
wonderful, wonderful. I am now going to introduce the Dean of University Libraries, Harold Hickson.
Thank you, Jane. So thank you all for coming. As Jane said, I'm the Dean of the Libraries here. I've been here since August of 2015, and before that I was at USF St. Petersburg for 6 years, which is where I first met Kenny Cruz. I want to thank Jane and her colleagues and the Center for E-Learning. This workshop is being jointly sponsored by the libraries and by the Center for E-Learning. So for me, that's a natural partnership. And Jane, as the Director of Scholarly Communication, has been the lead planner for this workshop and has been working with all of you and with colleagues in the libraries and in the Center for E-Learning to pull this workshop off. And it actually, Jane knows it takes a lot to pull together a workshop like this. So I want to thank her and her colleagues for all the work that they've done here. Now, Kenny, as you may know if you've read his bio, is an attorney, he's an author, he's a professor, and he's an international copyright consultant. For over 25 years, his research, policy making, and teaching have centered on copyright issues related to education and research. He established and directed the nation's first university-based copyright office at Indiana University, and was later recruited to establish a similar office at Columbia University. He currently serves on the faculty of Columbia Law School and has a law practice and consultancy with the firm of Gibson, Hoffman, and Pension. Now, Kenny is the author of numerous publications, including Copyright, Fair Use, and the Challenge for Universities, which is a reevaluation of the understandings of copyright and fair use, and the well-received Copyright Law for Librarians and Educators. Is the recipient of the Patterson Copyright Award from the American Library Association and the 2014 Mark T. Banner Award from the American Bar Association, among many other accolades. Now, I'm a friend of Kenny's on Facebook, and I watch his world travels. I'm here, I'm there, he's everywhere around the world. He's always out speaking on this issue, clearly has a passion for it as well as a deep knowledge about it. So I've known him for many years, and I brought him in twice when I was at the University of South Florida, St. Petersburg. At USF St. Pete, distance learning was one of the services of the library. We didn't have a separate center for e-learning. So for me, the partnership between e-learning and the libraries is a very natural one. It's one that I believe works very well. So you're going to find Ken to be not only extremely well informed, but also very tuned in to the challenges that faculty in particular are facing in this challenging world of scholarly communication and how it's changing. So without further ado, I'm going to get out of the way and let Kenny interact with you.
All right.
Thank you.
Thank you. Wow, thank you. Thanks for that. I'll take a bottle of water though. I might need that. It is water, isn't it? I'm sorry. You never know. Thank you. Well, thank you, Carol. Thank you, Jane, Jeff, everybody. There's some familiar faces here, people. I've had the pleasure of being in the room with you before. And thanks to all of those out there in TV land. I think they can also see us as well as hear us, can't they? Watch out. We can see you too. We see that little screens up here. So this is, thank you, as we say, an interactive presentation. I had the very helpful step that you took. Many of you prepared questions in advance, and those were forwarded to me. So I could see some of the main places where you have questions already and are interested in different subjects. I like interruptions. So I will be up here with my slides, but you know, if I'm more than a few minutes into this and you haven't interrupted me already, I'm already putting myself to sleep. And I'm in a different time zone. I'm in some California time zone right now. So I'm counting on you to like startle me with some shocking question that challenges me. And so I'm looking forward to your questions as well. The issues today are about the way we relate with copyright. And we do it in so many ways in our universities. And one way we do it is by celebrating. Is everybody aware that this right here and now, hi, welcome to the program. That's all right. You were bringing the refreshments, right? One way we interact with copyright is by celebrating it. Did everybody celebrate all week long that this is Fair Use Week?
We got a parade.
Yeah, parade, throwing beads, that kind of thing. Yeah. So it's Fair Use Week, an annual event now marked around the world, celebrated as well as derided around the world. You know, because fair use is one of those things that really divides us. Other than that, we are a 100% unified country, aren't we? Absolutely. That's the last political comment I'm going to make. But fair use, because if you read a lot of the blog posts, and there are a lot of them out there this week, related to the fact that this is Fair Use Week, it's helpful and fascinating to see the deep-seated opinions about fair use. And just going right to the core, and you'll see where this comes from as we get further into these slides, that goes right to the core of what fair use and what copyright are really all about. One blog post will praise fair use for its support and the way it encourages and allows creativity and the next generation of creativity. And the next blog post will say, it's Fair Use Week. This is a time to realize how much fair use kills creativity, that it is the enemy, that it is wearing down copyright, and it's copyright protection that supports creativity. These are two very different worldviews of the role of copyright and the role of fair use. And so it's important for us to not only understand where we really are, whether we like it or not. It's very important to know that. But it's also very important for us to have opinions and to have a point of view, whatever it might be, whether you agree with me or that person next to you or somebody else, it doesn't matter to me. It's more important that we think about these issues, that we have an understanding that there are facts and there are opinions, and both of those are really, really important. And it's important for us to get a handle on both of those. So welcome to Fair Use Week. Thank you for celebrating it. I think that's what we're doing here today. Because a lot of what we talk about will be about fair use, but it will be a lot more. So what about copyright? Big picture kind of things about copyright. Well, what does copyright do? It grants rights. The basic structure, you'll see words coming right up. It provides for a set of rights given to copyright owners that last for a long period of years that are subject to exceptions and limitations. Fair use is just one of many of those. A lot more coming up. But it's not certain things that we kind of often think it is. It's a matter of law. It's remarkably little about money. Money is rarely mentioned in copyright law. It's there in a few esoteric places, but it's definitely not what the law is all about. It's about that thing we've already said. It's about encouraging creativity and protecting creative expression and encouraging through fair use, etc., further creativity, I think. It's not really about property, although we tend to call it property. You know, the lawyer labels of intellectual property and so on, but it's really fundamentally different from other types of property in the way we use it, the way it expires, the way it behaves in other ways. And it's not about all rights. I am the copyright owner. Well, that doesn't mean I have all rights. It means I have the rights that the law gives me. A bit more about that coming up. So copyright is also important, and the reason why we're here is because it's everywhere. We're going to see, and I'll tell you right now, why it's everywhere. And that is that copyright, for a starter basic rule, that copyright protects original works of authorship. And original means it came from me, I originated it, and courts have interpreted that to mean it has some minimal level of creativity. So it's original works of authorship that are fixed in a tangible medium, meaning it's written on paper, it's stored on your computer, it's captured in your camera, it's whatever else it might be. It's fixed in tangible medium. So it's everywhere. We can look around the room, you know, and there's a lot of copyright that's plainly visible to us. The flyers and handouts, a book, the notes that you're taking right now, the slides, the photographs that I took of the Netflix.
No.
Sounds. Must be somebody on one of the tables.
Is that an original work of authorship?
It is now because it just got recorded.
It got recorded, so it's fixed. So hey, you know, it's performance art, and so you know the picture that's up there on the slide is my photograph where I leaned over at the petroglyph and snapped a photograph, and then I chose where to crop it and adjust the color and light a little bit. So there's original work of authorship, some tiny little bit in what I did, not much. But if that Native American who first created the underlying artwork were alive and doing that today, that would easily be an original work of authorship fixed in the tangible medium of the rock, of the stone. Instant copyright protection. And notice there's no little C in a circle that artist chiseled into the rock as well. Don't have to do that. That's old law. It's out there floating around, but is it required? No, no, no. So that's a key reason why we can look in the room. And, you know, even though there's not like, you know, exotic artwork and a lot of different things in the room, there's still a lot of copyright in this room. And because of that, we're all copyright owners and we're all copyright users. And in both capacities, we have a lot of choices. A lot more about all of that coming up. And so some of this I've already said, you know, new uses and the new types of works and so on and so on and so on. And the list can keep growing. All of these words and these concepts that are on this slide put us on a path that has us bumping into copyright. I'm not going to say we have a copyright problem, but I'm going to say all of this raises copyright questions. that for many of our projects, it's significant enough we need to stop and figure out what the answer is before we move further. So this is why we're surrounded by copyright, why we in our expanding use and creation of works, the innovative things that we're doing, this is why we are constantly bumping up against copyright questions. Not problems. We're not sure they're problems, but they're at least questions that at some point we need to sort through. Speaking of questions, any questions so far? Yeah.
So you present around the world. Are the standards for copyright similar in all Western countries, or do we need to be aware of things now that we might be using copyrighted material from around the globe?
Great question. And I think we were warned, they can reliably pick up the sound, I believe, yes, to the other locations. Great questions. You ask in Western world, and one way to answer your question is the rules are roughly similar in the Western world, the Eastern world, the Northern world, the Southern world, all around the world. Because a lot of the fundamentals, like how do you get copyright, original works, etc., is registration and copyright notice required? No, that's a rule, and that's one of the fundamentals. How long does copyright last? A lot of years. The basics of those rules are set by different international agreements, treaties, if you will. And the big one is the Berne Convention, B-E-R-N-E, capital of Switzerland. And the Berne Convention's been around since the 1880s. And about 165, give or take, countries are signatories to that. And it sets a lot of the substantive rules. And so in nearly every country of the world that you can name, we have the rules. The key word that's used in this era of treaties is harmonization. The basic rules are, as I say, roughly harmonized so that there's some degree of predictability. But the place where there isn't harmonization is one of our big topics for today, and that's fair use and other exceptions. Those different countries go in different directions. So what's fair use in the United States may not be anything in some other countries.
So for a country like China, the issue is enforcement rather than they don't have the rules?
Yeah, all the talk about marketplaces and so on, tons of this and that. All of that talk is largely an enforcement question, and it's more than China. Often somebody from China will then say, yeah, but if you've taken a look at the streets of New York, and the list goes on, the list goes on. So there's an enforcement question, and there's an enforcement question probably in every country of the world. Yeah. Great question. Okay, take up my clicker again. Let's see what's on the next slide. Well, let's get started. An example of creative work, ownership, and fair use. This is a photograph of a book, and I'm kind of embarrassed to say that's my hand pointing at that book. But what I'm pointing at is that little rectangle, artistic rectangle in the middle, is one of those wonderful rock and roll sort of psychedelic posters from the 60s and 70s. The entire book, and it's 300 plus pages, is all about the Grateful Dead. So everybody rushing out to buy your copy right now? and every page looks like this. It's a mashup of text, photographs, posters, other kinds of material. It's a rich treasure house of content of different types. And here came the lawsuit, because Bill Graham Archives, not to be confused with Billy Graham, but Bill Graham was the rock and roll concert producer famous from the peak of his career in the 60s and 70s. And Fillmore East, Fillmore West, everybody having flashbacks, right? And so nobody's even having flashbacks.
We didn't use the last.
No, we're all just like too far gone already. And so anyway, Bill Graham Archives said, hey, wait a minute. You know, we produced those posters. They were advertising concerts. And you reproduce them in the book. That is an infringement of our copyright that we own. And there were 6 or 7 in this particular book that were owned by Bill Graham Archives. And they all kind of look like that. They were kind of small. The originals are this big. And in the text of the book, they're very small by comparison. And the court ruled, well, now, for starters, notice copyright protection easily for this artistic work and so on. There's a serious question that clearly was settled to the satisfaction of the parties, that Bill Graham Archives actually owned the copyright. You know, who was the artist, in what capacity did you produce this, etc. That was not an issue. So the issue in this case was whether or not this is fair use to reproduce these posters in this book. And the court said, yes, this is fair use. And this is the Second Circuit Court of Appeals. Court of Appeals, the intermediate level court of the federal system, said this is within fair use. Now we're going to see these factors of fair use. But one of the factors is, first factor is whether the purpose is commercial or non-profit educational, for example. This is a commercial product. This is a book published by DK Publishing, a major commercial entity. They hope to get rich from it. The authors hope to get rich from it. It's a commercial product. That doesn't stop it from being fair use. Just as something being nonprofit education, which is all of us, doesn't necessarily mean that it is fair use. This is one factor. We've got more factors to go. And that's not the total analysis either, because the court said even though this is a commercial product, its other purpose is to educate and inform the readers about the era, about the artistry, about the music, about the history, and so on. So we often do socially beneficial things like that, informing the public through commercial channels, like most newspapers, for example. And they are commercial entities. So that doesn't stop it from being fair use. And one of the other factors is the amount used. Well, this is the whole work. It's the entire poster. But the court thought differently about that question. Said, yeah, it's the whole poster, but it's a small size. And so the reduced dimensions of the poster went to that factor of the amount used. And it's low res. If you snapped a picture of this and tried to blow it up into a full-size poster, it would turn all grainy and not look very good. So the pixelation and the resolution became a fact that the court took into consideration about thinking about fair use. This case is really fascinating in so many ways because it also is kind of a breakthrough case of a high-level court saying that here's how we're going to rethink much more flexibly our understanding of how fair use works for new kinds of works, for new materials in a new context. We're going to see more. So let's see if we can make sense of this. Let's get down to some real kind of putting fundamentals and concepts of copyright in their place. This slide, to overstate things, summarizes essentially all of copyright law. Oh, geez. If I could get all those massive volumes and everything down to one slide, it would look kind of like this. So what works are eligible for protection? Here's our full analysis. Think about that rock and roll poster. Well, we've already said the answer. Works that are original works of authorship, psychedelic poster, fixed in a tangible medium. It's printed onto the paper, if nothing else. So that's easily going to meet the requirement. So we have instant, at that point, instant automatic copyright protection. So if you're right now taking notes in your own words, these are my words, but you're saying, yeah, here's what it means to me. And you're taking the facts, but you're rewriting them in your own way. Instant automatic copyright protection. At this point, if I said, how many of you are copyright owners? Would everybody raise your hand? Everybody. Everybody. If you're big enough to grab a handful of mud and smear it on the wall, you are a copyright owner. Congratulations. Right? Yes, please.
Okay, so I've been holding this question for like months.
Okay, you've been holding it in for months?
Holding it for months.
I know this has been a long time.
Nobody can answer this like the way I want to hear answer. So, for example, if I'm an instructor, and I'm sorry if I'm jumping ahead, and I am building a course and building my PowerPoints, and I'm snatching stuff off of Google
Mhm.
for the purpose of informing my students, am I infringing upon whoever is the original owner's copyright, and do I not have the right to do that?
You're way ahead of us.
Okay, I knew it. Okay, I'll back off.
Okay, but we're gonna get there.
Okay, we can get there.
Just say it depends.
Okay, it depends.
I knew I was ahead. I just thought it was the time. Go ahead.
Do you feel better getting
Yeah,
that?
I
out?
do.
That's right. Sorry. However, let's answer the little piece at a time, all morning long. Okay, let me answer one piece of that. Well, first, I'm not sure what snatching something off of Google means.
Copy, paste.
I guess I thought you meant. In other words, it may not be Google. You used Google, you could have used some, there are other products. Name one. You can. Yeah. Remember Alta Vista?
Netscape.
Yeah, Netscape. Remember Veronica? No?
Remember Gopher?
Gopher, Archie, yeah. Flashbacks. You remember flashbacks? So okay. The upshot of it is, you use Google as a tool. You go out and search the internet, and then you found things on somebody else's website.
It's just in the images section.
Yeah, I know what you mean. But those are, I mean, some of them may be on some Google site, but almost always they're a third party
Yes.
site. Yeah, and so you go there maybe and you find it. So let me just answer a piece of your question
Okay.
now, and then we'll get to more of it a little
Okay.
bit later. Just on this first bullet point, you went out on the web and you found some pictures. Okay, they're photographs, they're artwork, they're whatever they are, maps, could be any number of different things. Those works, probably in 99% of the examples we could make up, are going to meet that first bullet point. They're going to be original works of authorship that are fixed in some tangible medium. If I go on vacation, I take a picture of the beach of Florida. That is just my aiming the camera at the waves and snapping a picture. I'm not going to claim it's more brilliant than that, but it's my original work of authorship that's fixed in the tangible medium of the storage device inside my camera. And so I'm going to meet those requirements pretty easily in just about every situation we can make up. And then I'm so excited by this picture in the vacation I took. I posted on the web on a blog post or put it up on Flickr or whatever, and the world can find it. I am the copyright owner, let's assume, because it's a pretty safe assumption. And I don't know anything about copyright. I'm just somebody who went to the beach. That's all I am. I still have copyright. And just because you found it publicly available on the web with no restrictions stated, no copyright, it's still, you pretty much have to assume somebody else's copyright protected work. So we're kind of at this big yes on these first steps. And we see, well, we'll get to various, and we get to it this way. So how do you get protection? We get it automatically. We're done with the first two bullet points. How long does that protection last? A lot of years. The basic rule in the United States and in a lot of countries around the world is life of the author. So when I take that picture of my beach vacation to Florida, plus how long does that copyright last? It lasts for the rest of my life. It's going to be a long time, threatening the children. Plus 70 plus 70 more years. That's a lot of years. So if it's a beach vacation from the 1890s, maybe it's in the public domain. We got to find out how long that person lived. and then add 70 years. But as you can see, copyrights last for a long time. And then once it expires, then it enters the public domain. Somebody is the copyright owner. Couple basic rules there. General rule, if you're the one who created the work, you took the picture, you wrote the paragraph, you're the copyright owner. Copyrights can be transferred. That's going to be one of our last topics of the day. If you come back for the session about publication agreements, we'll get into that a lot more. And then there's this thing called work for hire, that if I did it as an employee acting within the scope of employment, then it belongs to the employer. So we got to figure out the circumstances. Did I take that as just a beach vacation photo, or did I take it as part of, my job was to do land, calculation, plotting, etc. And this was part of my job of putting together a study of land use for the company I work for. Then maybe the copyright isn't mine, even though I'm the one who snapped the picture. It belongs to the company. And then, so we have to figure out who the owner is. And then are my uses infringement? And if you reproduce in copies and there are various other rights of the owner, like the example you gave, that becomes infringement unless it's within fair use or some other exception. A lot more about fair use coming up. Okay? See the full analysis of your question? See where we've gone? I saw a hand up over here. Jeff.
Derivative works is not listed here, and I haven't done.
I was trying to get it down to one slide.
I understand that. My question to add to your question. So let's say you grab an image and you have a big image, but you decide to just take a piece of that image, okay? Now, that piece of that image is still copyrighted, all right, but it's not the whole, it's a part. And then fair use deals with that to some degree.
Mm-hmm.
But is that considered a derivative work? And let's say I change the color of that image, okay? And so at what point does that change make it a new work separate from the original?
Great question. And the answers, there are a couple of different ways of looking at it. You look at it from this angle, you're going to get one approach. You look at another, and I'll explain what I mean by that. So let's start making sure we grasp your first really, really important point, which is, let's think about the rights of the copyright owner. If I reproduce the work, that's one of the rights of the copyright owner. So, oh darn, what have I done? If I distribute it in copies to the public, the statute says, that's a form of infringement. So I made photocopies and I handed them out to the big group assembled in the room. There could be two infringements, making the copies and the distribution. There's another right of the copyright owner, public display. I took that picture and I showed it on the screen to a big enough group that the concept of public is rather elusive in the law, but at some point the group constitutes the public. And public performance. I read it out loud. I recited the poetry. I sang the song. I pushed the button and played the music. Those are all forms of performance. And if it's a public group gathered, then it's a public performance. And then somewhere in the middle of that is derivative works. And derivative works are where you take the original existing work and you reconstitute it, you rework it, and you transform it into some kind of new work, but you carry over that original work, existing work, into the new work that you're creating. Now, the breaking point that I think we're looking for is a struggle, is at what point am I using the underlying work and still carrying it over into a new work? A classic, easy derivative work example, somebody writes a novel and somebody else makes a movie based on the novel. The movie is a derivative of that work, of that underlying novel. And so that's a classic example. So where's the breaking point between I carried over those pieces, I made a new work, but I made it so significantly different and new that, and I use so little that it constitutes fair use. If somebody writes a song and I do my recorded version of the song, That's a derivative work. If somebody writes a song and I'm, got any Miami people in the room? What's Luther Campbell and To My Crew? And I transform it into, take the Pretty Woman Roy Orbison song and turn it into a rap parody, critical commentary on the underlying theme and message of the song. I'm bringing over elements of the original song and I'm turning it into something that's so new and so different and serves a social purpose of commentary, and that the court was ready to say, that sure looks like fair use to me. So at some point there's that break in there. I saw a hand up over here. I think there's somebody in our outside land here who's.
Oh, yes, absolutely.
Yeah.
Gentleman online, he wanted me to ask, can a faculty member show a DVD movie in class? Is this not a copyright infringement on distribution?
Great question. Great question. This is really good. No, it's even better than that. I think what we'll get at, and I don't want to jump ahead too many slides, so you'll see where it fits in when I get there momentarily. But look at the last couple of bullet points on this slide. You know, are my uses infringement? That's half of the question that came in, because the question is, if I show that movie, now the way I understood the scenario is somebody has a DVD, never mind where they got it. Let's just assume it's a legal copy, etc. You bought it somewhere, you checked out of the library. And what I really mean by never mind, I don't think it makes a difference, as long as it's a legal copy. And then you carried it into the classroom. You put it in the machine, and you showed some or all of the movie up on the screen. Playing the movie is a performance of the copyrighted work. If the group gathered in the room constitutes the public, and you know, a big classroom full of students arguably is the public. Rather than argue over that, Congress said, let's resolve this question. Is it fair use or even something better? And in this case, fair use is just one exception to the rights of copyright owners. There are others in the statutes as well. And one of them is this. It's a very brief, really nice, helpful section that references whether that allows the performance or display of a work in the live face-to-face classroom as part of the educational process. I'm paraphrasing. The upshot of it is, if I have a lawfully made copy, it does reference movies, songs you don't have reason to believe are not lawfully made. If I got a lawfully made copy, I bought it at Target, I checked it out at the library, it arrived by Netflix, and I didn't sign an agreement to the contrary. I bring that disc into the classroom, pop it in the machine, and show it. There's a whole separate statute that says that's okay. So I think I've answered this person's question with some really good news, because there's another statute that allows that. However, I almost always get the next question, the follow-up question. Great. I only want to show pieces of this movie and pieces of this movie and pieces of this movie. So I'm going to dupe those pieces onto my one copy onto my computer, so I can just make it easier to show in class. I'm going to do that. 5 minutes here, 5 minutes there, 5 minutes of another one. I always get that question next. Well, the statute I described doesn't cover that, because the statute I described allows the performance of the work. It didn't say anything about copying. It didn't say anything about copying at all. Bring the DVD into the classroom. That's okay. So now what we've done is we've taken ourselves out of that other statute that gave us such a good answer. And there isn't another statute except fair use. Now we're back to fair use. A lot more about fair use coming up. I think I answered that person's question, and I hope they didn't walk out on us.
One more piece of that.
Okay.
Can you do the same thing digitally is the next question. In other words, if it's long over distance.
There's room to argue. I don't lose sleep over that one, you know. Well, I may be thinking of something a little different from what you're thinking of. What I was thinking of is the common situation, especially at a big university like this. You have the collection of DVDs in the library, and often there's a networked system. So you can put the DVD into the machine in the library, and then it's transmitted through the network to the classroom, and it shows up on the screen way over here. And there's a technical argument to make that would not be allowed, but I don't lose sleep over that one. However, the one that is more problematic, I think this is what you're thinking of, is now I'm teaching distance ed. So now I've got multiple locations, or I've got students who are going to access this at home at their own time. It's the asynchronous model. So now what we're talking about, especially in the asynchronous model, is clipping, loading onto a server. Students will view it when and as they have the time and ability. We've stepped out of that statute that I described entirely. We're into either, there's another statute that applies to that, but it doesn't work very well. So pragmatically, we're really back to fair use for those clips, for those pieces. Question?
Does it matter how I make it available to people digitally? If I just put a link and they go to the unauthorized use?
Take out the word unauthorized, because I'm going to mix up the scenario a little bit. If your situation is you are making the copy or somebody on your behalf and putting it onto the server, we're back to figuring out what fair use means in that context. And that's all. If it's fair use, it's authorized. It's authorized by the law. And so we have to get ourselves to the point where we're comfortable with that decision making. And by contrast, if it's already out there on somebody else's website,
YouTube?
it's up on YouTube. If you know or have real reason to believe it's not there lawfully, ethically, more than anything, you probably shouldn't link to it. Legally, I'm not sure you're in serious trouble, but ethically it raises questions and problems. On the other hand, don't be quick to assume that because it's on YouTube, therefore it's illegal. There's a lot of stuff that used to look like it was illegal. It's actually up there with authority of the rights holders. Movie studios are taking their backlists of old films that aren't, drawing in a lot of money anymore from Netflix and other sources, and putting them up, the whole 2-hour film, thousands and thousands of them up on YouTube, because the little bit of money that comes from advertising is more than they were getting from any other source, or music. A lot of people are uploading, taking their favorite 3-minute popular song and uploading it onto YouTube, and it's staying there with the permission of the rights holders who've negotiated with Google to put advertising and get a share of the money back. So they're kind of waiting for you to think you're breaking the law, and then the other parties sit back and say, let's make some money off of this and make this work for the betterment of all of us. So don't assume just because it's on Google it's unlawful. Hope to see you again.
And with YouTube, do they have use statements on some of the videos? I think if you click down, they will have use statements.
There are sometimes some use statements, usually not. I don't see them very often. But don't assume. Don't assume. If we were in this room 5, 6, 7 years ago, I probably would have said, if you find it on YouTube and it's this feature film or whatever, watch out. Today, I'm not so cautious. Question here, and then we'll get this question that's outside.
Personal, but as a parent, my daughter, when she was in preschool, they often showed movies to the kids.
In the classroom.
No, more for entertainment, as a reward, special occasion. And same in the elementary school. Is there any sort of age limit with doing this?
There's no
Especially if it's not classroom.
there's no age limit. You know what? Let me read something. Let me read you. This is I'm gonna make a performance now of the language from Congress. I mean literally, this is a performance, reading this language out loud. The following is not an infringement. This is real brief. This is as good a statute as you're going to get from Congress ever on anything. This is it. This is not an infringement. Performance or display, showing it, singing it, acting it out, reading it. Performance or display of a work by instructors or pupils in the course of face-to-face, that takes out the distance in, face-to-face teaching activities. So I would turn to the preschool instructor and say, is this teaching the kids anything? And the instructor would say, yes, it's teaching them to be well behaved. And I would say, I'm really glad to hear that. And we would go to the next word. Face-to-face teaching activities of a nonprofit, to skip the for-profit ones, educational institution. It doesn't say college, it doesn't say high school. Educational institution, I think preschool qualifies. In a classroom, so that is a physical component, or similar place devoted to instruction. That's really flexible.
Yeah.
So, if they're gathered out on the lawn and sitting down singing songs, that's a place devoted to instruction. If they all go to the gymnasium and sit in the bleachers and watch it on the big screen, for the moment, that's a place devoted to instruction. So that's pretty. So, I think the answer is we can get to a yes somewhere under there. To follow up on that point?
Yeah.
Yeah.
So, and this supersedes the Disney factor.
Okay, say that again. Oh, we're in Florida, aren't we? Shepherd law. Oh, is it? So it's super. What do you mean it supersedes the Disney?
Well, I don't know a lot about this, but I know that Disney, has a death grip on their copyright. And case in point, preschool, we know what kind of movies they're going to show. I'm sure.
I don't know. Well, the short answer to your question is, Disney's just doing their job.
Yeah.
They got their products. They've been enormously successful with them. They got the right to go out there and protect them. They're just doing their job. But if there was nothing in what I just read to you that says there's a special rule for Disney. So Disney knows that the story that's been percolating around for many years is the preschool that painted the Disney characters on the wall, and Disney sent them some nasty letter. That's different because that's reproduction of their work into the paintings on the wall. That's different. This is about just performing and displaying the work. There was another scary, stupid story from 10 years ago about the music industry sending off nasty letters to the Girl Scouts saying you owe us money for singing around the campfire. And it just didn't take long. It just didn't take long for the rights holders to realize, you can go overboard on these things. You got to, just like I'd say to all of us, you got to know your rights, you got to know your opportunities, and you just got to tread in a way that's understanding and sympathetic of different views. There has been a hand up over here for quite a while.
Yeah, we have two questions.
Okay.
One question is...
One at a time.
Yeah, exactly. Would you like me to ask both the questions, then you can answer them? And
Yes, just one at a time. Then we'll keep moving around the room.
okay, so
Pick one.
first question here is, what if the lecture where you are showing a movie or clip is recorded via Echo 360 and stored on Canvas for students to review later? Would that not be covered by the statute that allows for live face-to-face viewing in an educational setting?
It would not be covered by that statute because the statute only applies to performance or display. And what you described in that scenario is reproduction of that film because you're capturing a copy. And so basic rule, and I've said it obliquely, I'll say it a little more emphatic right now. Here's a basic rule about fair use. You will have your situation. And as we're going to see a couple of times during the course of the morning here, you're going to, there's a set of other exceptions. And we focused in now on one of those other exceptions. That if you fit within one of those other exceptions, great. That's what I mean by the last bullet point. Sometimes there's something better than fair use. There may be a statute right on your issue. But that's a real rare treat when that happens. Those statutes typically don't cover exactly what you're doing. So your other basic rule of fair use is if you don't fit one of the specific statutes, then you have kind of, part of the cliche, second bite of the apple. You get to go to say, well, let me take a look and see if it's fair use. So what I would do at this situation is next say, but maybe it's fair use. And by the time we're done with this morning, I hope the person will have a much more thorough understanding of fair use to be able to think through whether this might be fair use. Sound good? Before we get to the second question from abroad here, somebody else in the room.
I just had a comment on the elementary school playing the video. If it's a for-profit daycare center, they would not be covered.
Because that statute only applies to nonprofit educational institutions. Yeah, so if it's the daycare center you're running out of home, that's your business. Yeah, now, like the DK publishing and the rock and roll posters going in that book, remember what the court did in that case was it allowed fair use even by a for-profit commercial entity. So what you're doing with copyrighted works in that for-profit educational institution could still be fair use, but there's less of it in the for-profit context. Fair use is a little bit tighter when we do the full analysis in that context. Question in front.
What happens if I in the lecture and I have a link to somebody else's lecture which is on the public domain and they have some topic I think is very interesting,
Yeah.
could benefit to my my lecture.
Okay.
And then could I just point to that link and say, hey, watch that on certain sections?
Yeah. Now let me adjust one thing you said. You used the expression public domain. And I think what you meant by that was it's something you found on the web and it's freely available. Anybody can go drop in and see it. Let's just call that publicly accessible, freely accessible. Public domain for us in this room means it is without any copyright protection. That's not going to be true, as we've already said. Most stuff you're going to find on the web is probably going to be protected, especially anything made within the last century is probably going to still be protected by copyright. So you found something that's freely available. I often give those out to my students. Take a look at this item, take a look at this. And I'm just looking, I just might be watching for any red flags. Do I have real serious reason to think that this is a violation of the law, some kind of infringement, when it's the fact that that piece of music or film or whatever is up on somebody else's website? Maybe it's not. Maybe it's perfectly fine that it's there. Maybe they had permission. Maybe they produced it. Maybe something else. We just don't know. So just watch for red flags that would say to you, maybe I shouldn't ethically be using that. But other than that, go ahead and send people to that other source for that material. Generally, that's fine. Yeah.
I just want to follow up on that question a bit about the public domain,
Yes.
because we all use the internet for sources, for images, for
We all
videos.
do. I
We
do all
all
the
do it.
time too.
How do you tell when it's public domain? I mean,
Tough one.
that's a really tough one, because
It
I
is
know
a
I've
tough
looked at images, I'll do the Google search and I'll look for, things that say they're in the public domain, and yet when I look at a specific image, sometimes it's like, that doesn't seem like it's actually free of copyright restrictions. So how do you
Correct.
tell?
It's really tough because as we said already, just my vacation pictures, the copyright lasts for the rest of my life plus 70 more years. That article that I wrote for a journal, rest of my life plus 70 more years. That work that's a published report that was a work for hire for some company, and they put it up on their website. Well, how long does that last? It lasts for 95 years from the date of publication of that report. So these copyrights last for a long, 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 long time. So generally, we're talking about much earlier stuff. And the law of copyright expiration gets extremely complicated. There are few hard and fast rules under American law. And one of those rules is if it were published in the United States before 1923, then it's in the public domain. So some works, there's a little class of works that are easy to spot. The newspapers about World War I, for example. But newspapers about World War II, that's a hard question. The law is very complicated for the works from that time period. And then there's another big category, and that is works of the United States government, where Congress, in enacting the law, chose to say that works of the U.S. government are without copyright protection, are in the public domain.
Yeah.
But be careful, because what's a work of the U.S. government? If I go pick up that brochure at Everglades National Park when I drive in, it looks like it came from the National Park Service. But what if they contracted out to a designer to put that nice, classy brochure together? What if the photographs all came from the local professional photographer? Those aren't works of the U.S. government anymore. And sometimes we don't really know. And what if we go to a state park or a county park and they hand us a similar brochure? States and counties are allowed to assert their copyrights. It's just the U.S. government that's without. I saw your hand first.
Well, it's rare that I'm in the same room with an attorney.
Oh, you need to be in trouble more often.
So, yes.
Now we know he's led a nice, genteel life.
Oh.
Yeah.
Well, it's all an act, but okay. And so I just have a basic question about the legal process.
Oh, yeah, good.
In our society, very often it's uncharted territory.
Mm-hmm.
We don't know we're breaking the law necessarily until we land up in court because someone has accused us of this.
True.
And so because sometimes this is uncharted territory and because sometimes, I, as partly an educator, get a little confused about where I'm going. I'm wondering, in your estimation, is it fair to say that attorneys for the copyright holder have to go pretty far to prove intent to infringe? Because it's uncharted and because I know ignorance is not an excuse in the eyes of the law, as they say.
Right. You're in most situations, you're better off knowing what you're doing. And I don't mean that facetiously. That's true.
So I'm curious, just in your experience over time, have you seen that courts have been fairly merciful against individuals who just really didn't know?
Even better. Very little of anything we're talking about ends up in court.
Okay.
Even better. Now, there have been cases involving certain Florida universities, involving certain other universities that we might all know and love. And there have been cases. But, relative to the number of things going on out there, these cases they don't even show up as a blip on the chart. So, and we'll talk about some of those cases. You're in the 11th Circuit, which the Georgia State case is involving scanning of pages. We're going to talk a lot more about that, more so in the afternoon, but we'll get to a piece of it this morning. And, but it's really rare for any of this to really hit the courts. Most everybody has an interest in seeing what we can do to wrap this up as quickly and as painlessly as possible in a typical kind of situation. Plus, especially on fair use, there's some protections for you that are built right into the law. That if buried in the law is all this scary dollars, and penalties that can happen if you get sued and you lose. You could be held liable for this much money, big dollars. But then there's written into the same statute is a protection that says that if you are part of a nonprofit library, archives, educational institution, and you copied the works under circumstances where you believed you were within fair use. Think of somebody recording that class experience that includes all that copyrighted stuff. But you got yourself to the point where you believed you were acting within fair use. So that's subjective. So you have to know what you're doing. And you had reasonable grounds for that belief. You went to some event, you got some material and information, you applied it in a reasonable way, and you thought you were doing the right thing. That there's protection that can cut some of those dollar damages all the way down to zero. So there are protections built in if you did your homework. So ignorance is not bliss in that case. You got to know what you're doing. So that's part of our job here, is at the very least, when any work with fair use you do after you leave this room, that you've said to yourself, wow, I got to at least think through some of that stuff I learned. We're going to see the 4 factors of fair use. I got to apply them in a reasoned, good faith way. If it's a high profile kind of example, take some notes and put it in a file and put that in your desk drawer. So if anybody ever calls you on what you've done, you can say, look what I worked this through. And that'll help protect you a lot. Plus, if you're the copyright owner and you don't like what somebody has done and you're going to file that lawsuit, it's very expensive for you. It's going to cost you, $50,000, $100,000 out the starting gate pretty quickly, pretty easily. And if it goes to trial, it could cost you millions of dollars. So you're thinking to say to yourself, how serious is this? How quickly can I wrap this up? Plus I've got to jump through some hoops and make sure I've properly proven that I created it, that I own it, that I have to have a registered right in many cases to file the lawsuit. There are things I have to do first. And I may not be quite ready for all that either. So I've got an interest in wrapping this up too. So we're going to meet. I'm going to send you a nasty letter. We're probably going to meet, and we'll see where this goes.
Thank you.
I've been promising it. One more offsite question over here.
Yeah, we have a question and a question that many are having. So the first one is, so if it's a private or profit school, is it allowed? And the second one is the statute you keep referring to, can you make mention of the statute numbers that can refer back to it?
I can give you quick answers to both of those.
Thank you.
The statute number that I just read is code section 110, subpart, like parentheses, 110.1. Section 110 is a lot of fun. If you're a copyright geek, it's sort of our bizarre idea of fun. But section 110 is this long section. And it has a subsection in there. First one, subsection 1, is what I read to you. And it's really brief. It's like one sentence about performance and displays in the classroom. And it's really helpful and it really works. And we live by it, routine basis. Subsection 2 is about the clips and uses of content in distance ed. And it's a mess. And it's really not, it was enacted in 2002, Congress and everybody thought we figured this out. Here's our answer. And unfortunately, it looked good on paper. It did not look good in practice. It just came unglued pretty quickly. And very few universities use it. So they revert back to fair use. And then you get into this really cool stuff. Like subsection 3 is about singing religious songs in churches and places of worship. Take that. You go to church and you stand up and you sing that hymn to the jail, all of you, because you're making a public performance of that song. It's a massive copyright infringement going on, and in our places of worship on a routine basis. And Congress said, okay, we'll give you little guys a little break, and made it not an infringement to sing the songs. But that doesn't cover making copies of the music and handing it out. Ooh, don't bring that up on Sunday morning. So the and there are other provisions in there for music stores to play the music. This is promoting the music. There are other provisions in there, detailed provisions about performing of music in shops and restaurants and bars and so on. Very elaborate provisions. They're paying a lot of money for the performance rights for that. They don't fit within the exception. There are provisions in there for horticulture clubs. You know, so 4-H or somebody showed up with their lobbyists and got their exception, and the list goes on. And the list goes on. It just kind of reads like who showed up. And Congress was really putting this together. It's really fascinating. It's really fascinating. So I lost track of the other half of the question was something about nonprofit profit. That 110 subsection 1 applies only to nonprofit educational institutions, but fair use can apply to both. Somebody else had a hand up over here. Yes.
I just kind of wanted to go in more detail on the Fair Use Act. when it
Oh, we got a
comes
lot
to-
more about fair use coming out.
Like with videos, like we have a lot of videos going around, but they don't have closed captioning. And if we don't have copyright permission from the owner, if we try to caption that,
To make the caption.
because it's not available.
I'll tell you what, that is a fair use question. We're going to have a whole lot more about fair use coming up. So can I ask you to just hold that
I
one?
can
And then let's see if I don't answer it along the way, ask it again. Non-fair use questions, all the way in the back.
I don't know whether it is or not, just hold it
You don't know
and
yet?
let me, I'm getting a headache right now listening to what is this.
No.
After now, we've been talking about what we as instructors can and cannot do, right?
You mean like for years you've been talking about that?
No,
I mean in this room,
here.
which is
Most
not
of
like
the
years.
examples, as instructors, what can we do? I teach in the College of Education, we teach future teachers,
Yes.
right? And many of their products that they do in the classroom for us is what they might do as teachers in the future,
Excellent.
right? So I'm taking notes. Okay, you can show the Disney movie, but only if you do the whole thing. You can't show clips, this, that, and the other. So a lot of what our students produce, on the one hand, is related to these kinds of things. The other is a lot of what our students produce is also, we encourage them to be public about that. So they're not just teaching their students in their classroom, but upload it somewhere in the public domain so that it is a social support system for people, it is public education, all of that good stuff.
Good for you.
Now, I'm going to have to tell them, you cannot get your kids to see a small world after all and record that and give the DVDs to the proud parents at your end of semester, concert, because maybe they might come up there. I have no idea. So right now I'm in this weird kerfuffle.
And you were okay coming in. You felt fine.
Yes. So we don't have to address that right now, but I just want to tell you, here's my state of mind.
Where's the problem? I'm sorry, but you just described my whole life. I've been carrying this anxiety around. And I'm just so glad to transmit it to you. Well, it is tough. It is tough. And so let me say something really, let me answer it as generally as I can. A little paradox. I would be remiss if I didn't say you need to include copyright. It's just a fact of life into your thinking and your lesson plans and so on. It's just kind of the way things have evolved. That's where we are. And then on the other hand, don't sweat it. Don't give yourself that headache. Don't sweat it. Don't sweat it too much, But copyright to some extent needs to be part of the process. So to a middle school teacher, I would say, hey, good news and bad news. The good news is you can show those videos in the classroom. You can do all the stuff we talked about. Good news, there's a significant application of fair use that for most of your common situations, you'll get the hang of it and you'll figure out, you get a feel for what you can do and what you can't do. Not quite so good news. It gets pretty tight if we're talking about putting it up on the web. And I know I deal with that a lot in my own little way. You know, I will frequently have a version of something, some lesson plan, lecture, workshop materials that I use in a live setting. But if somebody says, hey, we want to put that up on the website related to this conference or whatever, I might have a different version that I post that goes up publicly, where maybe I've removed a few things, you know? So you know, does it create a little bit more work? Yeah. Does it limit education because you had to remove some things? Yeah, and you should, don't get a headache, but you should be concerned about that. You should be very concerned. And that's a reminder that a lot of what we do is in everything we're talking about here, except where the court then interprets it, is an act of Congress, you know? And part of it, get upset. Yeah, I know, they're not going to fix it. Don't worry. If I put that on in recording, didn't I? But get the, you know, but when you do get a chance, and chances happen, where you get a chance to present on behalf of the university, on behalf of the school, or a casual meeting at some, you know, where you're shaking hands with a member of Congress. And to be able to say, this is, your member of Congress showing up. But the, you know, the copyright's important to you. And you're just trying to be a law-abiding citizen, helping students and other people learn. And copyright is frankly getting in the way. And it really is. And I love authors, and I have no problem with Disney asserting their rights. I don't see them as the boogeyman at all. They're just doing what they're doing. And so, but I think that the whole equation of copyright needs to have ample support for this public interest in learning and access to reasonable pieces, you know. And I think we should be looking for a way to support that. As we work more into fair use, you might get a little bit more comfortable. Your headache might go away a little bit. Couple more questions, non-fair use questions. Go ahead.
I'm going to go back to Carol's questions because we got a question from e-learning where we hopefully addressed it the right way. There was a professor putting their class online. They had a whole bunch of images in their slides. And so we were asked, you know, what did they do to figure out which images were, you know, okay and not. And so what we said was, well, you know, you can do the reverse search on an image.
Okay.
And then if you can figure out the right keywords to find the same image in a Google search, you can use the limiter for fair use to then figure out if it's, you know, okay. Time intensive, yes, but it's.
Yeah. You know, in other words, you're describing a situation where somebody says, I teach here and I now want to do this innovative teaching resource and I want all these pictures.
Mm-hmm.
And guess what? They forgot to write down the sources of all those pictures, right? And they've been accumulating them for years off of web searches and so on, right? We haven't said the word plagiarism yet. and copyright is not very much about plagiarism. They're kind of cousins of each other, but they're different. Because when we get to fair use too, you'll see that among the factors of fair use, and I'm eager to get there, I want to get there right away, but among the factors is not giving credit. It's just not on the list. Credit is a plagiarism issue. It's an ethical issue. It's not much of a legal issue. And what you've run into, and that is if nothing else convinces that instructor to keep careful records and give credit where credit is due, that you end up with a future project where now you need permission. Let's assume, skip fair use for a moment. You need permission for those images, and you just don't know where to start hunting down that quest for permission. So to instructors and everybody out there creating new material, keep really careful notes about the research paths that you take, sources that you find, the images, text, and it's so easy to forget. I know from my own experience, sometimes I'll be deep into a paper and I'll have different sources, and then I'll look back even one day later and I'll think, that paragraph, did I write it or did I get that from someplace? I go, and then I got to go reconstruct what I did yesterday. Keep careful notes as you go. This picture, store it into a file with a note from this website, this source, and give credit where credit is due. We'll at some point, a couple times during the day, mention Creative Commons licenses. And Creative Commons licenses are a vast, hugely valuable treasure trove of material to support all of our activities. And a typical requirement is to give attribution. And I have seen cases, real live cases, where somebody goes out into the web, finds a Creative Commons image, uses that image in their work, the work goes up on the web, and they fail to give attribution. That's the only thing that the copyright owner asked for, was give me credit, and you didn't even do that. And guess what? You didn't exercise the Creative Commons license. You committed copyright infringement, barring fair use, etc. By failing to give attribution, you stepped out of the license and into the realm of infringement. You are on your own. You are on your own. Good luck. I hope it works out for you. Because, so just give credit. Give credit. And it'll save you all these practical headaches as well. Anybody out there in TD land got that too? The question on that?
Yeah, they're asking, what if it's posted online but password protected, so only those with the password can access it? For instance, if you build a work for class, but the course posts everything to an external site, like in college education, pardon me, we post projects to live text. Would we have to upload to live text an altered version without copyright materials? Live text is password protected and subscription based.
I'm not sure what subscription based means, but is the situation that the person asking the question is hosting the whatever content with a password protection to access that content?
Correct.
Okay, as opposed to the person's not saying I'm including in what I'm posting password protected content. That would be a different question.
They're only stating that what if it's posted online but password protected?
With the password protection. That's going to help. Okay, hey, hang on to that question, because we're going to go right to fair use. How's that? And when we get to, among other things, the Georgia State case, electronic reserves, and much more about that in the afternoon session. We'll get a piece of it today. But when you get to it, you're going to see how that password protection controls access, limits the possible effect and consequences of what you're doing in making that content available. You've limited it to just a small group, and that's going to help with your fair use calculation. Sound good? Was there a follow-up on that point? Okay, good. Let's get to fair use. Let's get to fair use. We need to be there, don't we? Yep. Okay. First, one of the other first lessons, I've said a few first lessons already about fair use. One of them is that it's one of many exceptions, and I know I've said this various times. And this is just a sample set of the other statutes that are out there. So the copyright law builds up in some of the early statutes of granting rights, long period of years, and so on. And then it carves out a set of exceptions. Fair use is one we're going to look at in greater detail. Others are very important for what we do at the university. There's a separate section for libraries. It applies to libraries and it allows them to do, under certain circumstances, certain things. So it's limited. It lets some libraries make some copies of some works for some purposes. It's very limited. But that's the nature of statutory language. And so if you don't fit within what it covers, then you can come back and see if fair use applies. There's something called the first sale doctrine. The first sale doctrine lets us share works. Share, and by share I mean not copy. I mean if you went to the bookstore and you found a book and the book happens to be about copyright, and the book is a copyright protected work, but you bought it at a bookstore or you found it in the library and you checked it out. That's a form of public distribution. And Section 109 says, but that's okay. We're going to let libraries check things out. We're going to let bookstores sell things so that we can allow these good things to happen. Section 110 we've talked about, displays and performance, especially in the classroom. Architectural works are protected, and certain depictions of architectural works are exempt, and there's an exception for it. And then Section 121, persons with blind or have other disabilities. There's a specific section allowing certain types of uses. It does not apply to the closed caption, though. So we're thrown back to a question of fair use. Okay, so where do these all come from? Our latest version of the law, enacted in 1976, the entity named Ford up here in this New York Times headline, he was president of the United States at one time. Gerald Ford, familiar name? Okay, and he's the one who signed into law the Copyright Act of 1976. It's been amended many times since then, but fundamentally it's with the law that we have today. It's rooted in the U.S. Constitution, which gives Congress the power to promote the progress of science and the useful arts. That's nice, glowing language with a social purpose. Promote the progress of science and the useful arts by securing for limited times, could be a long time, but it has to expire at some point, to authors and inventors the exclusive right to their respective writings and discoveries. This is nice, powerful, glowing language, which frankly the courts have interpreted to give very broad authority to Congress to make whatever, pretty much whatever, it reasonably deems to be copyright law. So let's get into just this piece of it. Section 107 is fair use. And to summarize fair use, it has these 4 factors. In determining whether any use of a work is a fair use, the factors to be considered shall include, and then there are these 4 factors listed in the statute. What's the purpose of the use? The nature of the work. Thank you. The nature of the work being used, the amount used, and the effect of the market. Effect on the work. Notice there's really nothing here, and there really is nothing here that says anything directly about money. It doesn't say anything about giving credit. That's not part of this. That's that plagiarism issue. And it also doesn't have exact measures about amount. There's nothing in the law that says 300 words or 10% or 30 seconds or anything like that. So where do these come from? This screen, even if you can't read it, that's okay. The main point of this screen is just to show you that this is the entire text of the fair use statute. It fits on one screen. This is it. So every question about what about rock and roll pictures? What about showing clips in the classroom? What about capturing it for distance learning? What about putting any closed captioning? Any of these? They're not mentioned here. They're not mentioned here. What we have instead is a statute that gives general guidance, gives us 4 factors to consider that we have to consider to be law-abiding citizens, and courts have to consider in order to make their determination. So you win and you don't win when it comes to these fair use cases. And it's a struggle. It's a struggle for many reasons, a social struggle, an economic struggle, a cultural struggle. It's an innovation, it's a media struggle, it's all kinds of things. And the issue has been exacerbated by the fact that works get automatic protection for a long period of years. That means we're relying more and more on fair use as the protection of copyright also expands. Here are a few more examples. Cariou versus Prince. Cariou is a photographer. Prince is Richard Prince, and the artist. And Richard Prince tends to take he calls it appropriation art, where he takes an existing work and says, here is my artistic take on that work. Cariou is a photographer, and he has these wonderful photographs of the Rastafarian people. I think these were all taken in Jamaica. And Richard Prince has taken those images and added to them and changed them in different ways. And here came the lawsuit against Richard Prince, saying this is like a question we had about how much can I change an existing image before it is something new? Well, the court concluded that this kind of change is fair use. You can see the original work on the one side, and then the Richard Prince version where he adds blue eyes and adds the blue guitar. Now this is a modest change, but in the same set of artistic works from Richard Prince, we get some other more significant changes. Again, the original photograph, the man riding on the burro, and then the Richard Prince take on it. You can see he's made multiple changes. He's added different colors. He's added new people that weren't there, and also changed the size. And this is a striking thing when it comes to artwork, because the originals are photographs, however big they are, but the Richard Prince versions as artistic works are enormous. You can see the dimensions. This is 131 inches by 100 inches. This fills a very large wall. So he's really creating, and I have seen some of these originals from Richard Prince. It has a very powerful impact on you as the viewer, an effect that's nothing like however beautiful and interesting the original photographs are. It's a very different consequence for the viewer. Very powerful. And the court said this is what's called a transformative use. It's not competing with the market. It's not affecting the market. And if you're offended by this, as I'm sure Cariou, the photographer, was, frankly, that's where we need fair use more than ever. Like the Pretty Woman, Roy Orbison, being changed by Two Live Crew into the commentary on male-female relationships. This is critical commentary. And the more offended we might be, the more we need the protection of First Amendment, which is part of a concept that underlies the application of fair use. These are tough cases. They are guaranteed to leave people unhappy, just guaranteed, which makes them all the harder for courts to decide and for the rest of us to accept. Speaking of Prince, the other Prince, this is not really about fair, this court case didn't really resolve that it was fair use, but in this case, there's the baby video, which you can still find up on YouTube. Mom is very pleased with baby. Baby likes to dance to Let's Go Crazy by Prince. And about a 30-second video goes up on YouTube with the baby dancing and looking all cute, and the Prince music playing scratchy, grainy in the background. And here comes the takedown notice from the music, from Universal Music, saying, remove this from YouTube, it is our copyrighted work. And then when that comes in, you're the person who posted it. You get to push it back up. You can respond if you want to, and they might have to put it back up. And what the court ruled in this struggle, what the court ruled was that in this case, we're not determining at this stage whether it is or is not fair use. But what we are concluding, we meaning the court, what we are concluding is music company, when you determine to send out that takedown notice, you need to at least give some passing consideration to whether or not this might be fair use. So it's pushing the fair use question, at least initially, back on the copyright owner, which is a fascinating development conceptually, because it's basically saying your rights as a copyright owner are defined in part by fair use. You don't own what is fair use. This is a major conceptual development, which no doubt, if you're looking at it from copyright issues from the point of view of a strong rights holder protection, you're going to find this very offensive. You're going to find that the carry artistry, the appropriation art, very offensive. This not only maybe offends you in substance, but maybe it offends you artistically and conceptually as well. And so, but that's what the law struggles with. And then notice I have a little box in the corner where I wrote down the credit. So if I ever, I'm saying, hey, thank you, newspaper, for putting some nice, helpful pictures in there that I could use. And if I ever need to go back and get permission for something, I at least have a starting point. At least. Even though I doubt that the mirror actually holds rights in those pictures, but at least I've got a starting point. I got a starting point. Good. Let's see what else we have. So let's bring all this back to us and use the rest of our program to talk about, how this applies to us. Think of all those situations. Every place where we might use clips of video, audio, newspapers, anything else to show in our classroom or to share with our students. Well, we've been struggling with this over the years. The Copyright Act of 1976 includes the Fair Use Statute that I showed you, and it's part of the law today. And when Congress chose, fair use had been around for more than a century already in court cases, but it hadn't been part of the statutes. And so when Congress chose to put fair use in the statutes, there was some concern from many different points of view, including from educators who said, wait a minute, if you put this in the statute, how do we know what it really, does it really allow us to do some basic things that we needed to do here at the university? And over the years, there have been different interpretations offered up. In 1976, in connection with the Act, some interest groups of authors and educators and publishers met to hammer out what were called the classroom guidelines about what can be copied, like photocopied, and handed out in class. And these have been around kind of haunting the calculation of fair use ever since 1976. I think they're effectively gone. The Georgia State case involving e-reserves didn't really say they're gone, but refused to apply them in a situation where the publishers were aggressively insisting this needs to be the standard. And the court refused to apply them, said no, they're totally inappropriate for many reasons, and pushed them completely out of the calculation. In 1998, there was an effort called the Conference on Fair Use, which brought a wider array of interested parties together. They met for about 3 years. I was at most of those meetings in the mid-90s, and hammered out some proposals for guidelines. And I think we can safely say they've effectively gone nowhere. They have just not caught on in all those years since they were put out. In the 1990s came a series of court cases about photocopies and course packs being sold, especially by commercial suppliers, Kinko's and others. And the court handed down some pretty stern rulings about what's not fair use when you're copying textbook chapters by a for-profit entity making a profit off of these copies. But they never answered the question about us, until we get to Georgia State and the Georgia State case. So we'll get to a whole lot more about that. Oh, those photocopy shops. The Georgia State case. The Georgia State case was in reaction to a new policy adopted in the Georgia system, university systems, adopted in 2009. And I should be quick to add, just as full disclosure, I had a role in this case. I was retained by the university parties, the defendants, and retained as their expert witness. So I filed 2 reports in connection with this case and then testified during the trial. And the trial was held in mid-year 2011, handed down a decision in 2012, which gave a really strong endorsement of fair use for the kind of typical circumstance of a brief portion, usually several pages, maybe a chapter out of a book, in the context where it was behind the password protection. We had some question about that earlier. So realistically, the students in the class are the only ones getting access to this material. It's tightly related to the educational purpose, and that it was all being done internally by the nonprofit educational institution. And most of that, most of the conclusions by the district court were upheld when the case went up on appeal to the 11th Circuit. Now, when we get into the afternoon session, we're going to see even more about some details about that definition of fair use. But it goes back to those same 4 factors. What's the purpose of your use? Nonprofit education. What's the nature of the work that you're using? Usually there's broader fair use for nonfiction fact-based materials, the typical stuff of education. The amount that you're using, a brief amount tightly related to the educational purpose, and then effect on the market. And the 11th Circuit did say you have to give greater weight to the effect on the market when it's straight copying out of this. Not like carry you in prints and we're creating some new artwork. No, this is straight copying. So we're going to give greater weight to the economic harm. And that meant that the court was looking for evidence from the publishers. Can you show us? Did you in fact make this available for licensing? Was it available? Was it available at a reasonable price when and as the instructors in the university needed it to meet the objectives of the course? So where the publishers said, well, no, we don't license that book for electronic delivery, only for print delivery, the court said, well, then I think the electronic delivery doesn't harm your market because you're not claiming that market. So it's a real push for the publishers. And since then, we've seen more and more publishers say, okay, hey, universities, we will make our prices maybe more reasonable, but we'll certainly take a whole lot more material and make it available page by page, chapter by chapter, whatever you want. And we're seeing more and more of this. And that frankly, is a good thing. It's good for the publishers, it's good for the authors, maybe it's even good for the teachers and for the students. But it's in response to this kind of definition of fair use. Question over here?
Yes, it said, one of the attendees said they followed this case, Georgia State University, GSU, and found that this case was still under appeal in 2016.
Mm-hmm.
Has this case been finally resolved?
There's a quick answer to that. The answer is no. So where are we with this case right now? A lot more details in the afternoon session. So please come back for that. But where we are with this case right now, district court in 2012 rules largely in favor of the university, goes up on appeal to the 11th Circuit. The 11th Circuit says, I'm going to adjust a few things here about the way you determine fair use. Send it back down to the district court to reapply under this new definition. The district court came back and said, we still think that almost all of the uses are within fair use, even under this new definition. That is now being appealed one more time to the 11th Circuit Court of Appeals. So all the arguments, the briefs have been filed in that case. There may be oral argument. It could be easily another year before we have a decision from the 11th Circuit Court of Appeals. What happens after that is anybody's guess. So let's look at a few more things. We need to be thinking about these issues as a university, as a group, as an institution, thinking about our role as individuals in it, and building a policy The policy at Georgia State relied on a checklist that I had originated with one of my colleagues some 20 years ago, and they did a variation on that. It works well for them. It may or may not work well for you in your circumstance, but still pull some kind of resources and build a workable, reasonable policy so that, again, we can get to that point where we can say, we believed we were right about fair use. We had reasonable grounds for that belief. That's going to show that we're good law-abiding citizens. It's going to protect us from a lot of the possible liabilities. And better than that, if you've done that level of homework and you've actually made that level of decision, chances are you're right, actually. Somebody's always out there to tell you you're wrong. That just goes with the territory. But if you ever get thrown in front of a judge and you've done that level of policymaking application homework, there's a real good chance you were right about fair use, and you may very well prevail.
Yeah, I was wondering about what if you're copying books that have gone out of print? They're just not available anymore. Are there any special circumstances?
That goes into this as well. The general sense, and some of the cases are in conflict over this, I'll warn you, but the general sense is that if it's gone out of print, there isn't a market that the copyright owner is actively seeking. And so therefore, when you get to that fourth factor, which is the effect of your use on the market for the work, maybe you're not harming the market because they don't appear to be looking for that market. That's generally the more accepted analysis. Saw your hand up over here.
Is that checklist available to us?
It is. It is. You can find it in lots of places. You can use Google. And then also, because it's been vetted by the courts, just go to the Georgia policy. Just look at Georgia University System Fair Use Policy. It'll come up right away off of the website.
Okay.
Thank you. So think about the role of libraries, the role of university council, and the role of education, not just for serving and supporting education in all of its forms here, but also educating your users about copyright, which goes back to that earlier question. So an e-reserve policy or anything else, think through its implementation, who is expected to really use it, follow it. And frankly, to the libraries and others who might ultimately be implementing the policy becomes a very valuable tool for how to helpfully define how you work with your faculty members. So the faculty member that says, why are we only doing this? You're able to point to the policy and say, because we're working through the legal structures, we're working through the copyright issues, and we're trying to reach the right result and treat everybody by the same standard here at the institution. So let's look briefly at a couple more, and I know we're supposed to go to 11, right? Yeah, coming right up. So just a quick summary of a couple of other kind of headline cases. Google Books. This case has run its way through the courts, and it went up. There's a petition to the Supreme Court. Supreme Court said we're not going to hear this case, which didn't come as much of a surprise. But we do have some very strong decisions by the district court and by the Court of Appeals supporting fair use, even in the context of a commercial for-profit entity, Google, scanning millions of full-text books and building a searchable database. Because a little bit like the Two Live Crew music, a little bit like the Richard Prince appropriation art, it is transformative. It is making a new and different use of the existing work. The existing work was there so we could read it and gain from what those words meant on the page. The Google Books project is there for data mining, and searchability, and indexing, and as also came up in a related case, Hati Trust, it had a lot to do with making formats available for persons who have print disabilities of different kinds. Lots of great language. But the other is the Hati Trust case, which stores and allows searchability of those tens of millions of books. And here too, the court said this kind of transformative use, where it's highly protected technologically. I think they were impressed, others are impressed as I read the case. I think the courts were influenced greatly by the strong security measures that the universities had put in place for this collection of books, and that there was no evidence of abuse, there was no evidence of any serious risk that others may be able to access and download these books, because that would certainly harm the market if we could find a way to hack our way into the database and put these up on some other server for the world to see. And so its added value or utility is not the test, but a transformative work is one that serves a new and different function from the original. When we do straight copying for our students, the court in Georgia State said, if that's transformative, it's not very transformative. But if we're creating a new teaching tool, think about the clips of video that might go into a larger tool that's wrapped with discussion and so on. Now maybe we've taken that little bit of, those few pieces of even a Disney film, and we've put them into an educational context. When I've taught contract law, I used The Little Mermaid for teaching contract law. It has offer, acceptance, consideration. It's got drunkenness, minors making contracts. It's got like the whole world of contract law built into this story of The Little Mermaid. And so I use clips of it in my teaching. And I felt really good about, it was live face-to-face teaching. Wasn't distance ed, but I felt good about fair use in that context if it came to that. And so think about new directions as well. As we struggle with fair use, the counterpunch to fair use is to say to each of us as authors, make your work more readily available. This rule doesn't apply to all of us, it doesn't apply to all of our works. But if we share it out through open access, if we say, I think this work is right for Creative Commons so people can use it more broadly, use that license so you can make your work more readily available, and you can help the next person who's trying to use your work from needing to go through all of these gyrations and get all of these headaches about fair use. So thank you very much. It's been a pleasure.